Okay, I think more are coming in. So far the 14. Okay, can we proceed? Looking at the question. So what do you think about the question? Uh, Macam mana? If you look at the question, you rasa macam mana? Anyone?
I
Tak ada.
think it is for
Ya.
us to find the juries that have that supports the use of religion in determining whether a law is valid or not. For instance, macam kalau positivist, maybe since Austin is a God-fearing man, so he gives an absolute authority to God, and he believed that God is superior and we have to obey God. So maybe we can use that to apply.
Okay, Austin. Austin, remember he acknowledged the law of God, but as far as law that is being practiced in society, he obviously realized there will be multi ethnicity, multi religious, multi things that can be seen in the society. So he says that in order for a law to be valid, it has to be objectively seen from the perspective of sovereign. So when it comes to sovereign, uh, he has his own theory, right? What theory is that? Command theory, betul?
Betul, sir.
So jadi just to takut nanti you swayed into discussing about God punya role in positive law, takut nanti that is the situation. He is more towards he acknowledged the law of God, but he look at the human law that we create, or the law that we have in our society is based on the impact of sovereignty, yeah, the sovereign person. He is talking about the person. It's not God. Good. Yeah. Okay. Good. Boleh nampak? Can you see the ni?
Boleh, sir.
Sebab jadi kita terus concentrate on that person and that person punya perspective in terms of the law. So jadi kalau you ambil tadi Austin, right? Kalau you ambil Austin, then you look at the command theory. Okay, the command theory which is talking about equals to the sovereign. Okay, the sovereign plus command plus sanction or punishment lah. So if you were to have that, then it will be what we call a valid law lah. So in other words, it will translate to valid law. Sorry lah, ni guna mouse saya. Nampak tadi macam ayat Jawi lah. Boleh nampak ni? Can you look at this and then it should be that lah. Okay. Anyone else? Kalau positivist kita ada berapa orang kita boleh ambil? We have siapa je?
There are 6 juries
Hani.
for positivism, sir.
Siapa? Fatin? Good.
Sir said that berapa orang. For positivists that we learn, we have 6 juries.
Siapa?
Other than Austin, it would be LA Hart, Carlson,
Very
Emily Dartheim, Benton, and Karl Marx.
Try to remove, kita restrict our exposure to only these three.
Okay, sir.
Boleh? So nama 5 markah kan, so 555 lah, 555. So 5 ni maksudnya you have to elaborate them, each one of them, right? And then on top of that you have to elaborate, yang ni elaborate lah, elaborate, and then you are to give example. Elaborate lah, ni example. So legal example, and then after the legal example then you apply. Macam highlight jugalah, lebih kurang. Allah, apa hal? Boleh nampak that situation. So baru 15 markah So 555. Then you have what do you call it? The elaboration, the explanation, the example, and then the application. So the same thing that you have to do with your presentation. So anyone else? Anyone else? Kalau you nak pakai HUD macam mana? Itu explanation of HUD. Mana guys? Mana?
As for hard, sir, is it like there keeping that there is no commands of the sovereign, but laws created by parliaments bind society and also members of parliament? It's his principle is a bit different with Austin. For example, criminal law or tax law.
How he does that?
I think for the present question, the parliament should make the resolution and it will bind the society.
Parliament should be
make the resolution as the law, or I'm not sure, sir.
Okay, tak apa. At least you are willing to try as compared to the other 20 of your class members who are keeping silent and just waiting for other people to make mistake. Aduh, hampa ni. Bukalah mulut. Awak mah sangat ni mulut ni. Okay. You are here, you are spending your time. This is the time for you to talk. Right? And give your interpretation. Macam mana? HUD. So who knows about HUD? Macam mana HUD? Fatin dah try dah. Good. Someone else? Hani, Ayuni? Are you here? Berapa group kita ada ni? Hani? Are you here? Yes.
I don't quite understand the question actually. So
The question.
for the resolution kan, what kind of resolution that she wants us to make? I mean, should we include like suggestions on how to make the society accepts diversity? Is that it?
Sekejap. Aduh, nak masuk. What does it mean? You don't understand the question or you don't understand my question? My question is...
I don't understand the question.
This question, right?
Yes.
So this question is giving you a problem, a situation, that is similar to those that is given in the exam. So kalau exam, there are questions that might lead to 2 pages of a question itself. So Kita tak naklah buat yang panjang-panjang macam tu kan. So kalau kita tengok ni, this is question 2018 December, which is 2 pages long. Okay, and the marks is 20 marks. So I don't want us to go into that yet. Okay, for the time being, I'm showing you an example of a quite simple question. Okay, very direct, very direct, and asking you who the question is asking you to elaborate. So we have historically kita tak buat lagi kan?
Belum lagi.
Kita dah buat? Belum, okay. So we concentrate on positivist and naturalist. So positivism kita ada 3, right? Austin, Hart and Kelsen. So now my question to you in class, Austin kita dah boleh nampak the sovereign, the command theory. Hart punya? This is my question. Hart apa dia? Apa yang dia punya, apa dia punya konsep, apa dia punya teori?
Can we relate it to the fact that he accepts morality as a guidance to determine the validity of the law? Since
that is secondary. Good. Secondary lah. He is a soft positivist as compared to Austin. Austin dia hardcore. He doesn't care about morality. Morality is nothing to him. Don't talk about morality to me. As far as the sovereign is concerned, whatever he or she says, we have to listen. Okay, if we don't listen, we can be sentenced to jail, just like MCO. MCO, though the person that is giving the command is the government, to him he doesn't see the government as sovereign. To him, he sees king, as we can see from the state or the nation of Arab Saudi, Saudi Arabia. We have Brunei, so they are in total control over the country. They can easily kill you by you not abiding to their command. Okay, because the law is below them. It is not the law. Even Al-Quran is below them. They can kill people if they feel that they want to kill. So that is how he sees the command theory is supposed to be as a valid law. Because if we don't have element of fear, then therefore that law is not law. So he is a hardcore. As compared to Hart, he is quite mellow. He mellows down. He says that he realized that not all laws are about punishment. There are laws that also in relation to some procedures where it does not contain any punishment. So there are laws also that reflects morality. Now he absorbed that kind of condition of law that is existing in the society. However, he is still a positivist. Now my question is, apa yang dia punya positivist tu?
Primary rules.
Yes, very good. Primary rules dengan
secondary rules of obligation.
Yes, very good. If you do your reading, you have to understand, for those yang terkejut perut kata apa dia pula primary rule, secondary rule, you have to do your reading with regards to your understanding of Hart by virtue of his primary rules and secondary rules, and then the concept of morality and things like that, because the question itself does mention about something along the line of morality. Ada tak? Religious tolerance, harmony, protection of human rights, that is some the intolerance, discriminatory practices, with regards to group in the society. So what you need to do is your reading must go along that line. Otherwise, you won't be able to answer your examination question. Kalaulah examination question tu datang dalam bentuk yang tadi I tunjuk tu. Okay. If it's in this nature, memang you akan terkejut bangunan. Right? So in order for you to be prepared, you have to do your own reading. Yeah. So far, since everyone is considered as silent, I'm not sure your extent of understanding of Hart, whether you know him very well more than I do, or you don't know anything. Itu yang I risau. If you know him more than you have learned from me, then it's good. Yeah, it's okay. Right? I am thanking you. You know, but for those ni yang diam ni, I have no idea who you are. Kan nak tanya seorang-seorang. Okay, yang
So may I
yes,
ask?
yes, Izzat.
Okay, so if we take HLR hard
Okay.
opinion, school of
Mhm.
thought. So, for example, if we choose like Article 11 pertaining to freedom of religions as a primary rules of obligation and secondary rules, can we explain the practices in Malaysia, which we could see that other than Muslim cannot spread their own beliefs? Can we do that, or we have like to find another legislations for that?
To him, any laws that you have is considered as primary laws and secondary laws. If you were to have that formula dia, ni had sorry lah, tak ada ni had equals to primary rules dengan plus secondary rules equals to good law. Okay, so here the formula is primary rule plus secondary rules. Now the question is, what is primary rules? What is secondary rules? You mentioned just now tadi, siapa? Siapa pula tadi tanya? Siapa tadi? Iza ya. So Iza
Yes, sir.
kata, primary rules ni apa? Artikel apa
Article
Iza?
11. Article 11 on
11.
freedom of religion.
Okay, freedom of religion.
Mhm.
Okay. So kalau freedom of religion, there must be law of the secondary nature that is coming to support the freedom. Article 11. So what are the laws that is going to reinforce the Article 11, which is freedom of religion? This is what you have to answer.
What about for example, for Muslim we have like Islamic for each state Islamic law, Islamic
Mhm.
family law, criminal law, and we have Sharia court. So that is the freedom for the Muslim to practice Islam.
Okay. Freedom to practice Islam. Okay, fine. Boleh terima. Others? It's only half of it. If Article 11 talks about freedom of religion, okay, in order for people to practice, where does it evidence to show that other races or other religion, other people, other society that is believing in other religion, are they free as what being identified in Article 11? You can cite kata, okay, for the Muslim dia ada we have what they call it state laws, state religious laws that is able to regulate, even that pun saya argue juga, freedom of religion tu dia tak boleh apostate. Apostation is wrong. Jadi
Sir,
kalau Had tengok Had kata ni apa ni, sekejap dia kata free, sekejap dia kata tak. Nampak tak? This one dengan this one dah contradict. Sorry, ada orang nak tanya kejap.
sir,
Yes. Oh, you angkat
I'm
tangan.
sorry. Yeah, sorry
Ah.
to interrupt you. Um, instead of saying the state power to enact Islamic law, can we put the other sections such as the case of the change of religion, which is the minors, they have to get both consent from their parents to change their religions. It means that the other religions do not have their freedom to practice or propagate their religion. They still have some restrictions under the yeah.
Macam mana? I tak apa dapat apa yang you try to say.
Before this, sir said that what is the evidence that the other religions can be freely practiced in Malaysia? So for illustrations, can we pick the case like titular or case of the change of religion for the minors, whereby I don't really remember the name of the case, but the case was the Qadi decided to change the religion of the children, but the court said that they have to get the both consents from the parents.
Yang Indra Gandhi pun you boleh pakai.
The Indra Gandhi one,
Ah.
and then there is another one.
There's
I don't
quite a
remember the
number of
case.
cases kan.
Yes,
So
yes, sir.
kalau kita ambil law, this is non-Muslim lah. So ini non-Muslim. So kalau lah non-Muslim, kita ada what type of law? Kita ada di legislative dengan kita ada the common law. Betul tak? Malaysian common law lah. Kalau Malaysian common law is from the courts. This one is from parliament. Betul? So can you have an example of parliament laws that is going to say that Article 11 is something that can be seen in our practice? Can you have cases? Macam you kata tadi cases kan? Itulah yang betul lah. Tapi do you have law or not? Maksudnya, to reinforce, meaning the law should have the legislation to come out with any laws or add some laws that is going to be in line with Article 11. Sorry lah, apa ayat, apa tulisan ni. Boleh ke? Boleh nampak tak?
Faham, sir.
Okay, so you have managed to do apa? You ambil case Indra Gandhi, you know, as an example, and saying that the courts, by virtue of their decision making, they are in line with Article 11. Betul? So that is by virtue of had is good law. Nampak tak? He says that it must be a combination between primary rules and secondary rules. So primary rules is about duty, I mean substance. Yang ni procedure. Procedure, this one is about substance. What is substance? Kita ambil, katalah kita ambil land law. So if land law is considered as substance, within National Land Code ada juga procedure. So kalau kita tengok whatever, you kena carilah apa dia yang substance. Registration of land is paramount. So you did not register. So that is substance. Maksudnya inti parti. But the procedure, in order for you to submit in terms of claim, form apa nak kena pakai, kita belajar kan. So maksudnya from heart, he says that as long as there is primary rules and the combination of primary rules with secondary rules, then we have a workable law. Kalau lah kata tak ada secondary rules, then the substantive or the procedural rule, maksudnya benda tu tergantung. Contoh paling senang ialah, you don't use this example, right? Kalau Quran kata suruh semayang, tapi Rasulullah tak tunjuk macam mana cara semayang, would we be able to solat?
No, sir.
No kan? So this is what Had is saying. Had tak pernah bagi example tu, dah saya bagi example tu. Jangan ambil sometimes student they quote my example that I use. So he says that macam the assignment yang you kena buat tu, it is based, National Land Code can be divided into two. One is substantive, one is procedural. So the substantive, according to Had, is primary rules. It shows you the right of you. Bila you show the right, doesn't mean the right is the right. The right is only the right when there is procedure to allow you to get that right. Lagi pening ke? Beres?
Saya faham, sir.
Ya, faham. Orang lain?
Faham, sir.
Ampun ni nak kena cari seorang-seorang. Letih. Diana. Diana dah panggil dah. Diana, where are you? Diana. Oh, Diana. Ada berapa Diana ni? Ramai ni, Jacqueline lah, Khalida lah, hampa ni pergi mana ni? The Dying Species, Muhammad Syakir, where are you? Muhammad Syakir,
Yes, sir.
Khairul. Kita tak boleh harap perempuan kita ambil alih lah. So dia orang nak woman sleep tapi dia orang tak mau cakap. Yes, Syakir. Macam mana? Can you give an example? Okay. Faham tak what I am explaining about heart? My
Faham, sir.
explanation.
Maksudnya
Okay,
dia kena compliment. Ada law yang
Compliment.
compliment.
Very good word. Compliment. So complement by virtue of the substantive must be complemented with the procedure. Okay, kalau penal code section 302 kata mandatory death for those who kill another person with intention, then obviously there must be a procedure of killing that person. Then you kena ada apa? Law apa? Untuk nak kill. Okay? Law apa yang kena ada? Diam pula. Syakir. Letih.
Sir. Sorry, sir. Internet.
Okay. Internet lah. Okay.
Okay,
So,
kalau if the primary law macam saya cakap 302 murder kan. So the secondary yang akan complement dia maybe macam not amounting to homicide, sir.
Mana ada. Tak apa, good try. As long as you open your mouth and try, it can be right, it can be wrong, lantak lah. Kita dalam proses belajar kan.
Alright.
Allah, apa ni? Okay, so somebody else nak tolong tengok dah lupa dah. InsyaAllah.
Sir, is it the process of proving the element of mens rea and actus reus? Does that?
Okay, good. How do you prove mens rea and actus reus?
Mens rea, we refer to the intention of the accused person, and to determine the intention, we look at the conduct of that person.
Okay, kalau mens rea, conduct tu kita nak prove macam mana?
Conduct, we refer to the present facts, the surrounding facts of the.
How do you bring the facts into the court?
We go through several procedures where we investigate maybe witnesses or families.
On what authority that you have the right to investigate?
If I have an order from my superior, then
taking you as the police, right? IO, right?
Yes.
Okay. Kita tengok what law. Okay, the authority is given from your boss to you to investigate that murder, right? Must come from somewhere. Power must come from somewhere. It's all law is about power. Okay, guys. For those yang tak nampak lagi, law is about power. Power to do things. If you have law, then you have the power. So if you say that you have the power to investigate, in this case is to do the investigation of that murder, where does this law come from?
Kalau Evidence Act, sir?
Apa dia?
Evidence Act.
Ya, lagi Evidence Act untuk nak ambil evidence, untuk nak cari the facts. Lagi?
Procedure codes.
Very good. CPC, lagi? Police Act. IO tak boleh buat kerja kalau dia tak ada kuasa kan. Otherwise dia akan jadi ultravirus kan. Betul tak? Dia di luar bidang kuasa dia nak ambil evidence. There must be ada CPC, procedure of how to collect evidence, how to, banyak evidence act is going to. So, in other words, the principle or the substance law is about killing. or sentencing a person to death. However, it must couple with laws that is considered as secondary. Ini primary, sorry. So, kalau ada primary, mesti ada secondary. Kalau primary stand on its own without the secondary, it will fail. It is not a good law according to Hart. Is it law? No, it is not law. It's bad law. Kalau tak ada ni. So it has to be macam example 302 is considered as substantive law, and the substantive law mesti ada dia punya prinsip ni, primary rules mesti ada secondary rules, which is the procedure. So procedure dia apa? Macam tadi lah, Police Act, CPC, Evidence Act, any other law that allows for the gathering of data in order for that person to be sentenced to death. Sini. Can you see that?
Yes, sir.
Sama dengan Simon Yu. Kalau Simon Yu talks about land, so where is the primary rules? Where is the secondary rules? Apa maksud primary rules? It's the substance. Okay, it is considered as the substance as compared to procedural. The procedure, mesti ada procedure untuk substance. For every substance, mesti ada procedure. Kalau kata suruh solat, mesti ada cara untuk nak solat. Boleh nampak? Okay. So, now, that is hard. Calcium pula? Aduh, dah ada lecture pula ni.
Calcium refers, it is quite similar to Hart, where to determine the validity of the law, he refers to a scientific approach where he looks at the legal norm. I remembered that in lecture, Sir ada emphasize on the pyramid system where we need to check the validity of the hierarchy. So whether the person that is making the law is valid. So for example, if the highest power of the land is the federal constitution, so we need to determine whether the federal constitution gives the officers or the authorities such power to make such law.
Question, is it the grand norm, ni silap ni. This is basic norm. Yalah. Ni basic law lah. Basic law, is it? I pernah confused kadang-kadang. So ini grand norm, which is the highest law. So we have legal norm. So we have legal norm. Katalah soalan, grand norm formulation ialah apa dia? As what you mentioned tadi. Is our
federal constitution.
Very good. Tapi kalau untuk China, kalau untuk India, kalau untuk mana Saudi Arabia,
the monarchs.
The monarch kan, the system that they apply. Okay, so if the system is based on constitution, then the constitution is the grand norm, which is the pinnacle, this upper area. Okay, that is the validity of all laws come from this. Ya, puncak dia. Kalau puncak dia lain lah. So you in exam jangan pergi kata grand norm is the federal constitution. No, it's wrong. Grand norm is based on the country punya adaptation of method of legal system yang dia orang pakai. Kalau dia pergi kat Thailand, dia beza dengan kita. Kalau kita Indonesia, lain pula daripada kita. So kita kena investigate what is the grand norm of each country. Now, kenapa pula grand norm ni penting untuk kita discover? Because ini akan jadi valid. So the validity of the ruling of law in that particular country based on the grand norm that is being applied in that country. Every country is different. So you tengok type of pyramid throughout the world lain, tapi structure dia lebih kurang menjurus ke atas. So what that got to do with the question? Now question ialah dia kata legal norm which is the norm that we use towards any offences ataupun any activity of law, it is based on how those people, how those people yang kat bawah ni treats a legal norm. Who are they? Case curi. Kalau curi, apa legal norm dia? Apa legal norm when it comes to curi? Ingat, we are talking about these people, bukan pencuri yang ni. Allah, kepala besar. Okay. Yes, anyone? Come on. This is orang jahat. Okay, it's not about him. It's about how the law treats him. The law, if the law is according to this system, then the law is good, according to Kelson. Soalan. Siapa yang tak faham cakap lah, tak faham. Siapa yang faham, share lah. Dah 40 minit dah. Tak masuk soalan lagi. Mana? Anyone? Salma?
Yes, sir.
Macam mana?
Saya still tak berapa faham sangat, sir.
Saya unpaudible. Kalau tak faham, cakap dah tak faham. Apa susah yang kata, sir, saya tak faham lah, tak nampak lah. I mean, open your mouth and say that. Tak mana tak faham?
Yang on the legal norm tu.
Legal norm. You tengok everyone, for those yang sama kawasan sewaktu dengan Salma, ini pencuri. Okay, pencuri. Kalau kita nak ambil tindakan dekat pencuri, apa tindakan yang kita kena ambil untuk dia dipunish under the law? How do you punish a person who steals? That is a legal norm lah. Takkanlah pencuri ada berbeza in terms of the activity ataupun the method of application of law. Pencuri semua sama tak? How do we treat pencuri? The class, come on. Somebody?
Ask him to pay back for the stuff that he steals, sir.
Okay. Macam mana kita nak, ada ke boleh kita suruh bayar balik? Kita ada, kan you belajar criminal law kan? You belajar MLS kan? Dalam MLS kita ada criminal law dengan civil law. So I'm talking more of the criminal law dulu sebab senang kan? Sebab nama pun curi. Macam mana? How do you treat pencuri? Bunuh dia? Pukul
Tangkap,
dia?
sir.
Rogol dia?
By appropriate punishment, sir.
Okay. Appropriate tangkap. Tangkap macam mana? Based on what law? Appropriate punishment based on what law? What is the norm to punish a person yang mencuri that you know of?
Penal code, sir?
Penal code, betul. Penal code is kuasa. Okay. So, okay. Sekejap I tulis ni. Penal code is a law. Sini, dia datang sini. Penal code dia bagi kuasa kat siapa? Untuk kes
The
curi.
enforcement.
The enforcement. So sini ada pakcik polis. Polis pakai macam tu. Polis lah any judge. So if you looking at those people yang treat ini mungkin lawyer ke ni AG ke, you know. Sini mungkin jail warden ke. So that person have to go through a process of dealing with all these people until he is either dia lepas ataupun dia jail. Ataupun lepas lah. towards dah masuk jail berapa lama, then dia lepas lah eventually, right? Ataupun terlepas waktu awal lah. Okay, dekat sini dalam the process dia terlepas free, right? Sini pun dia free. So apa proses yang kita ambil? Itu yang legal norm. Siapa yang tangkap dia? Pencuri mesti kena tangkap dulu kan? Siapa? Polis lah. Betul? Agree?
Yes, sir.
Yes, sir.
At least mengakulah. So kalaulah polis tangkap, polis tu dia based on kuasa apa? Dia still on power. Apa power polis tu? Daripada mana datang polis punya power? From semua manusia dalam Malaysia tak boleh buat apa-apa kalau undang-undang tak bagi dia orang kebebasan untuk melakukan sesuatu. You cannot be able to enjoy ITM as a student because there is law that allows you to do that. Can the Chinese go and enter into ITM?
No.
Yes,
No, sir.
no. Why? There must be a law that allows certain people to go into ITM and certain people cannot. You cannot go into somebody else's house, uninvited. Why? Because there must be a law that prevent you from doing it. Everything that we are doing is actually based on the permission of the law or the authority of the law. So does the police. Polis nak main tangkap orang, you ingat dia boleh tangkap orang macam tu je. Dia mesti ada authority. You dah belajar seizable offence, non-seizable offence. Okay. You dah belajar, I think you dah belajar penal code, right? Criminal law 1 and 2.
Yes, sir.
Jadi pakailah knowledge of that. So whenever we are talking about any person yang curi, kita akan ada process that you have to go through. Every procedure that is given to the people here, skeleton ni, semua ni people, tahu tak? Proses undang-undang tu. Daripada polis pergi masuk ke dalam masuk ke dalam tempat detention, and then bawa ke penjara sekejap, and then bawa ke mahkamah. Nak pergi mahkamah kena jumpa orang, bukan kita jumpa robot. Kita jumpa registrar, that pencuri akan lalu prosedur, nak kena jumpa registrar yang identify dia pukul berapa dia punya court case. And then dekat situ ada bailiff punya kerja apa dia, nak jaga dia kan. And then pergi ke mahkamah pula masuk dekat magistrate. Siapa magistrate? Kenapa dia ada kat situ? Apa undang-undang yang bagi dia ada kat situ? Kenapa dia ada kat situ? And then defense counsel, apa yang undang-undang bagi dia kuasa untuk dia jadi defense counsel? Attorney General pula, apa kuasa yang dia nak kena ada untuk ada kat situ? And then lepas tu jatuh hukum, siapa pula polis yang nak bawa dia ke penjara? Apa prosedur dia dalam penjara once dia duduk dekat dalam penjara? Berapa lama dia nak kena duduk dalam penjara? So all this from the moment dia curi sampai the moment dia keluar daripada penjara involve people yang handle dia punya case ni. Okay, now the question is, all these people yang kita identify tadi, they cannot do anything without the authority of the law. So you have to question each one of them, mana dia punya authority? Question. So if you question their authority, then you start to discover. Oh, ni daripada akta ni, ni daripada akta ni, ni daripada akta ni. Akta ni pula datang daripada mana? Oh, datang daripada parlimen. Parlimen ni pula datang daripada mana? Federal Constitution. Maksudnya you boleh buat tracing daripada dia orang punya bawah ni, you boleh cari sampai ke atas. Dan semua orang yang kalau you cari semua orang ni, you akan cari, semua akan jumpa dekat satu tempat, which is the ground norm. So tak ada issue of morality, issue of religion, issue of social, element yang impact the law. Tak ada. It is clear. The police are doing their job according to the Police Act, because bukan Police Act sangat lah. Dia pergi ke dia punya boss dia punya superintendent ke apa ke, dan superintendent tu dapat daripada chief superintendent pula dapat daripada ketua polis negara dapat daripada kuasa dia daripada ni delegated legislation, ingat tak belajar? So di chief punya polis dapat daripada Police Act. So Police Act pula dapat daripada datang daripada mana Police Act? Police Act datang daripada Parlimen. Parlimen yang buat Police Act, bukannya orang lain, orang tepi jalan yang buat Police Act. So Police Act ni datang daripada macam mana Parlimen boleh buat kuasa pula keluarkan Police Act? Dia orang dapat kuasa, Parlimen ni datang daripada the provision of the Federal Constitution. So bila you buat tracing of all the people involved in the process, you akan dapat punca dia. So kalau you dapat nampak triangle ni, this is considered as from Kelsen is good law. Kalau you buat tracing, ada caca merebah, sekejap dia ni tak sampai ke atas. Pasal apa punca kuasa? So for example, kalau ada coup, orang ambil alih negara secara rampasan kuasa. So they are in power. Once they are in power, they will implement their own laws. So kalaulah laws yang dia implement tu tak sama dengan piramid ni ataupun cacar merbah, say for example, PAS ambil alih kerajaan, dia suruh semua perempuan pakai jilbab, apa orang panggil? Apa orang panggil yang Zoro tu?
Nikab.
Macam yang macam
Nikab
apa? Mikap. Katalah semua Hindu, Cina, Kristian semua kena. PAS punya ambil alih. So does that law yang dia buat is valid or not? How do you determine whether that law is valid? Just because they took over the country doesn't mean that every law that they apply is valid. It has to have its structure. Maksudnya structure macam mana? Dia kena ada rentetan kuasa yang diberi kepada untuk orang bawah, polis untuk nak pukul orang tu. Kalau polis pukul orang, paksa orang pakai mikat ke whatever pakaian yang dia nak, orang PAS ni rasa so-called Islamic, right? Dia mesti nak pukul orang. So you akan tanya, engkau ni nak pukul orang ni, apa kuasa engkau? Mana engkau dapat kuasa ni? Oh, PAS dah bagi kuasa. Mana dia punya surat kuasanya? Saya tak kira, saya orang PAS, saya member PAS, saya boleh buat apa saja. Mana surat kuasanya? Kalau macam tu semua orang boleh pukul semua orang. Can you see or not? There is a structure. Whenever you are living in a society, there must be structure. Kalau tak ada structure, then kita might as well chaos. You know, the society is going to be chaotic because tak ada undang-undang. What do you mean by undang-undang? Undang-undang yang valid according to Kelsen mesti dia punya ada punca kuasa dia. And punca kuasa semua orang yang dalam that legal system yang kononnya nak buat sesuatu tentang undang mesti menjurus kepada satu. Boleh nampak? Oh, lagi tak nampak?
Boleh, sir.
Jadi lecture
Boleh,
pula
sir.
ni. Okay, now. Ambil lagi 10 minit yang kita ada ni, nak apply dalam benda ni. Macam mana?
Sir, for application, kita kena bagi resolution based on each the juries ataupun just one resolution?
Yes. Untuk Kelsen dia mesti ada answer dia. Okay. Sini kan elaborate, and then you give example. Betul? And then you apply. Bila you apply, last column tu mesti ada solution dia lah. Tak boleh lah, dia kacau. Faham tak? So ada 4 kolom lah. So what do you mean by the answer? The answer if you look from the perspective of Kelsen. The answer if you look from Hart. Answer if you look from Kelsen. So kenapa kita buat praktis ni? Supaya you akan buka you punya mata bahawa ada banyak cara untuk kita make sure that the law is correct. And each one of them doesn't mean that each one of them is the solution. You know, they are right at the same time, they are also wrong because their formula or their way of doing things makes sense, but it is not foolproof. Sebab there are other laws from the perspective of natural law saying otherwise. Oh, kalau macam ni susah lah. Kena ada structure. Kalau tak ada structure, kita tak boleh buat undang-undang. Tak boleh juga kan. Okay, so you kena tengok lah. So your duty is to take one jurist, tengok apa dia punya understanding of that jurist, bagi formula kalau ada formula, bagi law yang kita ada yang boleh kita nampak, but apply to the problem. Nampak tak? Apply to the problem sini untuk Austin, and then do your conclusion. Okay, apply. Baru structurally nampak cantik, baru dah dapat 5 markah. 5 markah. 5 markah. Sebab structure dia betul, jawapan dia macam cantik je. Okay, cantik je Kelset. Cantik je Hak. Faham? Diam lagi.
Faham, sir.
Faham,
Siapa nak tanya soalan? Yes.
I just want to try answering this question based on
Yes,
heart.
very good. Yes.
Just like I think it was Iza Frutina that proposed primary rules and secondary rules, and she mentioned Article 11. So and then for the secondary rules, I wanted to touch on apostasy, where it is legal in certain states such as Negeri Sembilan, Perlis and Selangor, but is illegal in Kelantan, Melaka, Pahang, Perak, Sabah and Terengganu. For example, in Kelantan, apostasy is a criminal offence punishable with death and forfeiture of property. Attempted apostasy is another criminal offence carrying the maximum penalty of detention and etc. So is it correct if we were to draft our answer for the draft resolution that we want to recommend apostasy to be legal in other states in Malaysia to uphold the freedom of religion under Article 11 for the primary rules?
No. What you need to do is to present there are various solution that can be seen from perspective of different jurists. And from the question that is, say, for example, you are concentrating on number 2, right? Positivist?
Yes.
Okay, if you want to answer on positivist, then you say that there are 3 jurists that is considered as positivist in nature. I will be discussing them one after another. The first person I will be talking about Austin, where with respect to the law about apostasy. Sini apostasy, is it apostasy?
Yes.
Mana perkataan apostasy?
No, I mean, because the way I understand the question is like they wanted a draft resolution that promotes the protection of human rights. So I was thinking if we touch on apostasy to show that Malaysia wants to improve in their protection of human rights and the religion. So yeah.
You kena pegang one of the jurist dulu. Jangan cacam merebak. Siapa yang pegang? You pegang Hart?
Hart. Yes, Hart.
Okay, good. Okay. Yeah, remember, one paragraph is all about Hart. Jangan you go somewhere else. Okay, fine. So kalau Hart, dia mesti ada primary, secondary. Where is the primary, secondary apostasy?
For primary, it's I wanted to use Article 11, freedom of religion. But for secondary rules, there's other
different states.
Yeah, different states that are.
Then it fails. It does not fail. It is valid for certain state. It does not valid from the other states. So in fact, kalau dia tengok Kelantan, right? They have every rights to do whatever when it comes to apostasy. So that contradicts with the primary rules. Primary rule says that you can go and choose your own religion. But how can we have a secondary law that say otherwise?
Yes, that's why this is what I wanted to put in the draft resolution.
Very good.
Want to change so that it is legal in other states, so that apostasy they are upholding the freedom of religion, the primary rule that Hart is
So
saying.
initially you have to say that the law that we have in Malaysia is actually divided into two. Some of the states says yes, some of the states says no. So if Hart is looking at the secondary rules which are divided, then he would not have agreed that this is a good law. Because the primary rule has to be firm and the secondary rule must be firm. If you have secondary rules that is divided, then what it does not make sense of the primary rules. So if Hart is here, he would tepuk dahi lah, kata, how can it be? This is not good law. So the law of apostasy is not a good law according to Hart. Because it does not make sense. Kenapa pula tak make sense? Yalah, you cakap dekat federal constitution lain. You dalam state law lain. Habis macam mana I nak kata, Hart katalah macam mana Hart nak kata this is a good law? Doesn't make sense. So you punya comment, you boleh kata from Hart punya position, he would say he disagree with the law of apostasy. Then you have to put in all the evidence lah. You say kalau you kata state sana tak ada punishment, state Kelantan ada apa, you have to bring in the evidence to show. Nah, good.
Yeah.
Good. Yeah. Be subjective. You can write anything that you want. Okay, the rest boleh nampak? Lagi 3 minit. Yeah, the rest ada orang nak respon? Ya Allah, kesian kat saya ni.
Faham, sir.
Faham betul? Farah, bagus.
Just a quick,
yes, Safia.
just a quick question. For
Yes,
natural,
please.
for a natural law,
Yes.
which juris should we focus on? Since kalau positif kan ada 3 for natural law. Are there
Natural law?
juris that we need?
Apa yang nak bawa masuk?
Maybe Jeremy Bentham, John Stuart Mill, John Rawls.
Okay, boleh.
Okay.
So sama dia punya plotting dia sama lah. You kena elaborate them and then give valid legal example and then you apply to the problem and then you do your conclusion. Tak kira setiap orang akan jadi lain-lain jawapan, lantak lah. It is what it is. Kan natural law, they different people, different point of view. Sama dengan kita tengok the elephant dengan the blind people. Every one of them is different. So there is no quick one standard answer. Habis kenapa you belajar benda ni? Iyalah kena belajar lah because every place that you go, they will apply different juris. Okay, tak kira dalam department mana you ada nanti, you duduk dalam legal fraternity, they are always, the government apply different law, the state apply different law, the nation all over the world apply different jurisprudential. Semua apply different jurisprudential. Tengok the R. Jurisprudential ni. Dah group lain nak masuk lah. Faham janganlah kata I need to have a concrete answer to this. Tak payah, relax. Okay? It is what it is.
Okay, so
alright. Okay, right. So time's up. Thank you so much for coming. Next time I'll show you pula cakap. Tak larat lah sembang. Bye. Assalamualaikum.
Thank you so much.
Thank you, sir.
Thank you, sir.
Sekarang baru nak sembang. Baru nak start. Take care. Hi guys, ni grup apa? Grup K Sekejap Pakai je lah yang tadi benda tu. Soalan. Tu pakai link yang sama ya. Dah 8 orang dah masuk. Good. Just to you are seeing my screen Okay, kalau you tengok ni, this is 2018. Okay, 2018 sebelum COVID tu. So ini soalan exam. So exam kita 70-30 sorry, 60-40. So 60% of the exam come from the hall punya examination lah. Ini soalan 1. Can you look at the extent of the question? Ini soalan 2, soalan 3, 4 dan B. So we are doing part B But as far as the exam question, banyak. You cuma buat 2 soalan ya. For the previous, dia kata answer all. Answer 3 of part A and part B, compulsory. So can you imagine, one question is 1 page. Kita tak buat lagi lah benda ni. Takut sekali lagi itu kerja buruk ni. Kita buat yang part B dulu. Walaupun part B kalau you tengok previous examination panjang. Okay. Soalan? Soalan? Macam mana nak buat soalan ni? How to do this? Yes, guys? Macam mana nak buat? Atira, Fadlina, Nufatin, Nurin. Nurin dah buka.
Sorry, sir.
Yes.
Nak tanya how, if you don't mind, can you explain the question you show right now, the part B? If you don't mind, can you explain what the question actually want?
The question here, this one, this question.
Dia punya fact tu, I don't understand lah, sir.
Ya, memang dia buat saja nak bagi keliru kan. Soalan, you know, nothing is easy, right? So apa yang you baca 2-3 kali, selalu dalam exam you nak faham soalan, you kena baca at least 5 kali. You baca 5 kali tak?
Maybe less than 5.
Baca dulu. Kalau you baca, apa yang you kena baca ialah cari orang ataupun organisation ataupun institution. Problem tu memang ada problem. Tapi kita objek dengan subjek. Kan? You cari apa objek, apa subjek. Sudah dia ajar apa pula ni objek subjek ni. Global submit. Okay, global submit ni is a object. MINAH United, object. Ada lagi orang? Objek lagi. Ada tak objek? Guys? Objek, apa dia objek? Global submit. MINAH United. So, bolehlah kita kata they are interrelated lah kan? Lagi? Objek lagi?
Media report?
Okay. Media report is, okay, boleh kita ambil, okay, media report boleh. Lagi objek apa?
Public authorities?
Public authorities? Mana public authorities? Mana? First paragraph?
Sir. Line keempat.
Public authorities, okay. Objek, okay. Kalau you belajar tentang public authorities, you are talking about whom? Public authority. Government. So kalau if you're talking about government, you're talking about executive, right? So public authorities are the one that nama lain untuk executive lah. And nama lain untuk executive ialah government. Dan nama lain untuk government ialah Malaysia. Object. Okay, Malaysia, public authorities, the government, the media report and the organizer. organizer. Okay, so that is object. Subject dia?
Religious tolerance and harmony.
Very good. Religious tolerance and harmony. Intolerance dengan discriminate practice. Right. So now you from the question you dah nampak ada objek dengan subjek. Betul? So jadi tengok question. Ini statement. Jangan kata ini soalan. Ini adalah statement. So sini yang soalan. Critically discuss. What do you mean by critically discuss? What do you mean by critically discuss?
Discuss in a very deep manner.
Discuss in?
Explain in detail.
Apa dia?
Explain in details.
Explain in detail. Itu explain. Critically discuss maksudnya?
Discuss each and everything yang related with object dengan subject tadi.
Then you have to be critical about it. What do you mean by critical? Then you compare and contrast. Yeah? So kalau you compare and contrast, then you should be able to identify whether that particular thing that you mentioned is something of a good outcome or not. Right. So critically discuss and ada N ni. And outline your draft resolution. Apa draft resolution ni pula? What do you mean by, what do you understand about draft resolution? Ini cancel lah, kita tak belajar lagi kan.
Solution for subject matter maybe?
Macam mana?
Solution for subject matter. Kita dah determine subject.
Yes. Betul. Good. Okay. So, simple je kan? You are to draft a solution based on whatever discussion that you have, which is regarding the subject matter that is related to the object. Okay. So, boleh nampak soalan? Nampak soalan, bukan cara nak jawab lagi ni. Takkan tak ada respon pun. Faham ke tak faham ke?
Faham, sir.
Faham? Siapa yang tak faham? Tanya. Jangan malu dengan geng-geng yang lain. Pedulikan mereka. Okay? Siapa yang tak faham? Jangan malu nak tanya. You are paying for the class. Tengok ni baru nak masuk. Cekik je. Right. Tengok. Ya, guys. Macam mana? Boleh faham tak soalan?
Faham, sir.
Okay, good. So, kalau siapa yang tak faham tu lantak dia lah. Dia malu nak tanya. Kan? So, once you identify the object and subject, you are to do what? You are to do to critically discuss and outline your draft resolution in context of the following school of thought pertaining to subject, which is religious intolerance and discrimination practices. By whom? By public authorities. Okay, which they disregard the cultural practices and allege human rights abuse in Malaysia by the public authorities. Yang jahat ni lah, dia orang ni lah. And you are on behalf of MINAH United untuk attack this group of people that they are intolerance, discriminatory, abuse of human rights. This is what happening for public authorities lah. Dia gila kuasa kan. Semua orang yang dapat kuasa ni gila kuasa. So kadang-kadang dia buat baik. Orang sekarang ni nak cari makan, nak buka kedai-kedai tepi jalan. Tak, majlis duk main, duk saman. I really don't understand them. Okay, orang dah nak mampus dah, nak bayar bank tak ada duit, nak bayar kereta tak kena tarik. Tapi tak, you jangan buat, you buat juga I saman. Jagalah dia orang, in other words, that you nak buat niaga jalan, okay? Tapi make sure you cucuk, make sure you pergi ambil lesen, make sure you cuci tempat. Kalau ada report memang naas kami datang. Kami akan check. Every week kami akan buat spot check. Siapa yang kotorkan tempat, tak cuci, kami akan saman. Baru saman. Janganlah kata, oi, you tak boleh buat niaga kat sini, I saman. Aduh. You jangan jadi orang kejam macam tu. Jadi ada kuasa nanti satu hari, gila kuasa. Okay, you look at the law, it is what it is. You know, berperi kemanusiaan. If the law doesn't work in order to bring justice to the society, change the law. Apa yang susah sangat? Okay, majlis bandaran tak boleh nak ubah dia punya cara, dia orang punya pentadbiran. Obviously, everything must have its positive and negative. Tapi, you look at the positive side. Kenapa tak ada negara lain okey je? Semua berniaga tepi jalan, tapi make sure lah benda tu hygiene, ada cucuk, kebersihan dijaga. Ini orang nak hidup pun tak boleh. So orang terjun bangunan lah, terjun titi, terjun apa. Stupid lah. Hate these people. Right, itu orang ambil satu. So many other things lah yang berlaku. Saya kadang-kadang give up dengan law. Okay, so coming back. Jom kita tengok. So, soalan. Do you have any questions? Untuk
So far no, sir.
Positivism, kalau dia minta, bagi 3 je lah. Yang 3 ni memang glaring. You buka buku mana-mana, baca pun, memang you dah tahu dah. Austin, Hart, Carlson ni memang satu group. Right? So 5 markah untuk Austin, 5 markah untuk Hart, 5 markah untuk Carlson. So jadi total dia 15 markah. Okay, macam mana nak dapat 5 markah ni? So you kena elaborate. Okay, you must be able to explain. Bukan explain siapa Austin, explain apa yang dalam otak dia. Then you bagi example. Example apa you nak kena bagi? Legal example. You tak boleh bagi mana-mana example. You kena bagi legal example to prove that his idea is right. And then you apply. Apply apa pula? You apply dekat sini lah. Apa yang doktor yang ni tadi belajar ni, yang you identify. And then you do your conclusion. Ini pun kira consider okey lah. Sebab sepatutnya soalan kata critically discuss. You kena lawan antara Austin dengan Hart dengan Carlson di 3-3 ni dalam satu soalan. Baru you dapat markah penuh 15 markah. Tapi kalau you attack, at least buat macam jawapan selamat lah. So you attack seorang-seorang. Tapi you kena compare and contrast sebenarnya. Tapi kalau you tak mau compare and contrast, dah kata sesak nafas lah, pening kepala lah, then you maintain 1, 2, 3. Clear? Boleh nampak?
Sir?
Yes, soalan, yes.
Sir, maksudnya compare principle Austin, Hart dengan Carlson ke?
You duduk kat sini, maksudnya you sebagai orang luar, you are here outside looking at these 3 people. Dia kata mengarut, you kata mengarut lah Austin ni, tak apa-apa punya formula, command theory. Mana kita pakai command theory other than state yang macam Brunei, macam Arab Saudi, you have sovereign yang in power. They are above the law. In fact, they are above than Al-Quran. Quran is the highest law of God, tapi pada dia orang negeri-negeri ni, they are the law. Right? So valid. You boleh kata lah, tapi saya percaya kepada Hart lagi better. Dan saya suka juga Carlson. That is critically discussed. Saya tak kata Kelsen ni mengarut juga kalau saya compare dengan natural law. Sebab pada natural law dia berbeza sikit lah. Tapi saya rasa kena tengok dua-dua lah. Saya setuju untuk Kelsen dan juga natural law. Tapi natural law ada soalan lain kan. So you explain natural law dalam paragraf lain atau page lain. So this is you. Bila this is you, you are very subjective. Meaning you tak ada siapa pun you setuju. Okay, you boleh ikut siapa yang you nak. Lantak lah. This is your life. Okay, so you would see, oh, habis kenapa kita kena belajar ni benda ni? Belajar sebab semua law yang kita ada dekat Malaysia dengan satu dunia berpaksikan kepada jurisprudence. You pergilah negara mana, pergi negara komunis pun sekalipun, dia pergi berdasarkan kepada jurisprudence. Karl Marx punya jurisprudence, semua satu dunia ni pakai jurisprudence. Jadi tak faham kenapa tak tahu pentingnya jurisprudence. Jurisprudence is so basic. Dia adalah the hidden thing yang kita tak nampak. Tapi apa yang kita lalui dalam hidup kita sekarang penuh dengan jurisprudence. Kenapa you bayar tax? Kenapa you duduk dalam ITM? The law says so. Okay, can the Chinese and Indian goes into ITM? Yes or no?
No.
No. Okay, kalau dah no, then why? Why can't they? Because
the law
yes.
so.
Because yes, tak dengar.
Law said so.
Yes, the law says so. Which law? Now, if you say the law says so, which law?
Federal Constitution.
Federal Constitution, which article?
153.
153. Right. So what I'm trying to say here is that we in our life, we do things that is, kenapa kita tak boleh kenapa kita tak boleh ada 10 tangki gas kat dalam rumah? Can you do that? Boleh tak? Saya punya pasal lah saya nak ada 10 tangki gas masak dalam rumah saya. You boleh apa? This is my right.
But then it's gonna affect others kalau benda tu meletup, sir.
Tapi benda tu tak meletup. Siapa yang peduli pula?
Collectively, sir.
Mana collectively? Mana evidence you talk about collective? Proof. Kita kena proof. Kita kena simply kata, oh no, tak boleh. So, banyak orang selalu kata, oh ni boleh, ni tak boleh. Proof. Tanya dia orang, apa bukti dia? Saya katalah, saya tahulah undang-undang. Apa cakap undang-undang? Oh, saya polis. Saya tahulah saya polis. Takkan saya bodoh? Yalah, saya tak kata awak bodoh. Saya kata, apa awak punya authority? Daripada mana kuasa tu datang? Section mana? Akta mana? Okay? So, basically, jurisprudence is everywhere. Now, we are learning these people in order for us to understand the law that we apply in our life or the law in everywhere else in the world. Benda you belajar ni bukan something yang orang kata just for the sake of exam. This is for the sake of you as a person that goes outside in the society, then you will know the basis of every law. Where does it come from? Oh, tak ada orang cerita ni kita belajar juris untuk kita. Nobody else knows about this. You are learning the secret of the governance of the society. Hanya orang tertentu tahu pasal had, tentang Austin, tentang Kelsen. They are the thinkers. Mengapa dunia ni kena handle macam ni? MCO punya rule on what basis? Natural law ke positivist? Kenapa dia jadi macam tu? Oh, kalau kita tak pakai natural law, kenapa tak bebaskan orang nak balik tengok mak ayah dia orang bila dia orang ada, mak ayah yang dah tua. Macam seolah-olah tak ada. Tapi ada setengah pula law macam ni LAW5 kena lepas. Ni macam mana ni? Hak yang orang yang miskin kena bayar 10,000 tu macam mana? Mana keadilannya? Where is the law? Whether the law is right or not? Apa foundation yang the law tu pakai? So you have to ask question. So balik kepada yang ni, kalaulah on the second question is talking about Austin, Hart and Kelson. Hart yang lain macam mana? Tak payahlah nak masuk. 3 je lah cukup. Okay, 3 ni pun dah pening kepala dah. Okay, now siapa? Adriana Sofia Abu Bakar. Adriana, where you come forward?
Yes, sir.
Okay, so Austin macam mana? Boleh buat apa dia Austin? Dia punya example, explanation. Ni. I'm here right now. Kat sini. Explain Austin. Macam mana nak jawab exam ni? Cepat.
Okay. Yes.
Iya, kalau depan I cekik-cekik. Right. Cepat.
Okay. So I need to explain Austin punya principle first, right, sir?
Betul. Apa dia? Jangan cerita pasal Austin. Siapa dia beranak mana, dia makan apa, baby dia buat apa, tak payah. Explain. Apa Austin punya ni? Formula.
Like the common theory of law. She said law is
Equals to formula.
Law is what it is.
Itu law is what it is. Law is what it is. Ini baru dia itu general lah. Law is what it is. Common theory of law. Formula dia apa?
Command plus sovereign plus
Command
punishment.
plus sovereign plus
punishment. Is it equal to good
punishment? Sanction lah kan.
Yes.
So formula dia macam tu. CTL equals to C plus S plus P.
Yeah.
Jadi mat pula Okay. Barulah kita dapat
the good law.
Very baru tak keluar pula G ni. Good law. Meaning barulah kita tanda every law mesti ada this C plus S plus P.
Yes.
Jadi example dia. Okay, good. Siapa the next person pula cari ni. Hampa ni kalau tak panggil nama tobat tak mau kata. Edit else. How do you pronounce this?
Yes, sir.
Jawab. Ni sini example. Bagi. Tadi ni dah cakap dah C plus S plus P. Bagi example, legal example. Senang gila. Come on. Seorang lagi nak kena cekik. Hampa ni kena cekik baru keluar benda Cepat. Quick. Letih. Tak tahu. Macam mana hampa buat apa? Duk main game ke apa ke? Hampa tak baca buku ke? Emilia, Adriana. Siapa yang muka nampak sini? Kita kena cari yang bawah-bawah sikit. Adriana, mana? Where are you? Edis lelaki ke perempuan ni? Edis lelaki ke perempuan?
I'm a girl, sir.
Okay. So Edis, ada jawapan tak?
Penal code.
Penal code. Very good. So penal code apa dalam penal code?
For
Mana sini?
Yes,
so
sir.
penal code saja, kalau penal code saja is wrong. You kena explain dalam penal code tu ada apa? Mana punishment dia?
punishment for murder, for example.
Kalau you nak ambil murder, you nak ambil section berapa? Section? You dah buat dah criminal 1 and 2. Section apa on murder?
302, sir.
Very good. 302. So kalau 302 is the penal code, how do you prove penal code ada tiga-tiga yang atas ni? Apa dia punya punishment? 302.
Gantung sampai mati.
304 bunuh sampai gantung sampai mati. Very good. Apa command sovereign dia siapa?
Government, is it, sir?
Ya, tapi ini tak samalah dengan Austin ni, sebab Austin dia kata command is coming from the sovereign, which is a he or she. Kita parlimen bukan he or she. Betul tak? Tapi you nak pakai Austin dalam explanation, you kena caveat sikit lah. Sovereign is not a person. For sovereign for Malaysia, when it comes to section 302, comes from a penal code. Penal code is not from the parliament. It is a collection of all laws before we receive our independence. Sama dengan National Land Code. It's a code rather an act. So you have to differentiate between act dengan code. Tapi now we are not talking about where does it come from. Kita nak tahu bahawa ini sovereign dia compare dengan Austin dengan sekarang ni penal code lain sikit lah. So you boleh lah kata though the penal code is not actually coming from a sovereign, but for Malaysia it is coming from a sovereign body, which is the government of Malaysia, by the collection of all provision of law from India, criminal code, implementation from India. You dah belajar penal code, right? So you utilize that. Now, yes, it does not exactly. Dia kalau nak sama betul-betul kat mana? Sovereign. Yang betul-betul sovereign.
Positively, sir.
Tak, negeri mana?
The king. The monarch. The monarch.
Yalah, monarch dekat negeri mana?
Brunei.
Bagi example. Brunei, very good. Lagi?
Oman.
Oman. Arab Saudi. Yes. Itu baru sovereign. Itu baru kena dengan apa yang Austin cakap. However, we still want to utilize section 302 by doing a caveat lah. You caveat lah sikit. Kata Austin ni dia kata sovereign actually a person of a sovereign, monarch. Tapi I'm utilizing it in a way that dia macam anybody that is empowered lah, that is empowered. So boleh you pakai Austin untuk nak explain this problem, okay, this situation. So command, apa command dia? Apa command dia? Command dia? Come on, guys.
Prohibition, sir? I mean,
yes, very good. Simple je. Very good, very good. Prohibition to you to kill another person. So that is a command. Do not kill. If you kill, I will punish you. Nampak tak? If command not to kill, and if you kill, I will come in and hang you. So who is giving the direction? The directive is the sovereign.
So
Okay, soalan. Yes.
May I ask, if I say that the command is for prevention, is it the same? Then is it prevention is the same like we prohibit? I mean, like we utilize the same principle, but we want to say that the command is to prevent people from killing.
Prevent? No, there will be a specific instruction not to do or to do. There are the positive and negative act. So what is positive act is to do, action, the active dengan passive. So active dengan passive you belajar ni dalam law of thought kan. for every negligence, it might come up from a positive or negative act. So you sebagai orang yang menyelamatkan seseorang, you are a lifeguard, you tengok orang duduk terkapai-kapai, nak lemas, tapi you did not do anything. That is a negative act, which is a passive. Tapi kalau you aktif, you pergi bubur klorin terlampau banyak, hampir orang tu mati. So for every action of a human being, dia akan ada dua. The law will come in, you kena bayar tax. You jangan bunuh orang. Nampak tak? You kena bayar tax, you kena jadi aktif. You have to do something. But jangan bunuh, meaning you are to be passive. Kalau you nak bunuh juga, you geram kat orang tu, tak boleh nak bunuh. Sebab you kena diam diri. So the law will come in to ask you to do either one. To pay tax or to not to kill. So kalau lah kata you tak buat apa yang dia suruh buat, maka dia akan punish you. Fine ke, masuk penjara ke, gantung ke, up to you lah. Up to that you pula, up to them lah. So that is Austin. Nampak? Legal example dah bagi. Okay. Kenapa you kena bagi legal example? Kenapa nak kena bagi legal example? Kenapa nak bagi section 302 as your example? Untuk? Come on. Kena cari pula. Fatin. Fatin dah Fazri Zatul. Fadil.
Yes, sir.
Yes. Macam mana nak buat? Apa soalan saya tadi? Apa soalan saya?
Kenapa kena guna 302 sebagai legal example?
Yes.
Sebab
kenapa?
Nak relatekan balik dengan
nampak arrow ni nak relate
dengan
pada
Austin?
Nak relate pada formula dia, bukan nak relate pada Austin. Who cares about Austin? Okay? So kita nak relate balik kepada dia. So dah habis dah. Apply. Apply. Sini tadi ada, kita dah buat tadi kan, objek dengan subjek kan? Did we? Tak.
Yes, sir.
Okay. So ini nak apply kepada subjek. Apa subjek dia? Religious intolerance, discriminatory practices, abuses. Right? Betul ke? Ada ke law yang akan jadi macam tu? Ada tak law yang discriminatory practices that you can show?
Ada, sir.
Apa? Law apa? Bagi contoh.
Kalau kaitkan, sorry.
Yes, tak apa.
Kalau kaitkan dengan Federal Constitution, like we have freedom to religion, of religion.
Okay,
So that because the argument that there are religious intolerance, that we have a law here in Malaysia that any people can maksudnya macam boleh beragama apa yang dia nak.
Betul, yang tu betul. Tapi I nak you prove yang Austin kata ada command theory yang bila kita pakai command theory tu, law yang kita pakai tu mendatangkan benda yang negatif.
Saya cuba, sir. Artikel 153 about discriminatory.
Kalau you pakai 143, okay, now you are there already. So kalau you nak pakai, yang lain mesti duk tanya apa dia, pasal apa pakai 143. Cerita sikit.
Sorry, sir, tak dengar suara, sir.
Macam mana?
Tak dengar suara, sir.
Macam mana you nak pakai 153 tu?
Because the constitutions focus on special positions for the Malays and the native of Sabah and Sarawak, especially in public service, educational privileges,
betul.
Special facilities, permits, license and so
What's
on.
wrong with that?
It's discriminatory to the Malays and the Sabah and Sarawak only.
Ya, macam mana yang discriminatory? Prove it. You cannot make a blind statement. Okay,
In terms
prove.
of education, dia ada University Awam just for the Malays people, such as UiTM.
So how come it is discriminatory?
So maybe because of preferential treatment.
Yes, apa yang preferential treatment tu?
When it comes
Apa
to
yang dia akan lead tu? Justify. Open up. You don't have fear inside your mind and saying that kita investigate. Cepat.
Maybe in terms of ada university doesn't even allocate specific who can apply for that university. But then for certain university, it's specific for only Bumi Putra and Malay. So that may cause discrimination to other races as well.
Oh, betul. I agree. Tapi you did not convince me. You have to convince me. Kenapa ITM Article 153 itu akan jadi discriminatory practices by public authority?
So maybe because UiTM punya fees kan cheaper and then they have many cawangan. So macam bila ada races yang poor cannot enter into any other than public university other than UiTM. So then the poor races cannot other poor races such as Chinese and Indians cannot enter into UiTM. And saya pening.
Tak apa. Tak. Kalau pening tu bagus because you nak dekat dengan jawapan dia. Guys, kalau bila you buat sesuatu, you rasa macam pening you dah dekat dah dengan jawapan tu. Don't worry. Okay? Sikit lagi. You akan jumpa.
Mungkin discriminatory kat situ kot sir sebab diorang dah miskin lepas tu diorang tak boleh nak masuk universiti yang ada cheaper fees.
Cheaper fees because they have to pay higher fees when they are poor, right? So when they are poor, you force them to go to other universities that is as private, mainly private lah kan? Because public dah memang it was yalah you boleh argue and saying that the Chinese can go UKM, but actually the half of we have 100,000 student, right? 100,000 all over Malaysia. So jadi the chances, probability of them to enter into a public university is lesser as compared to a BUI. So that is actually a means for a discriminatory practices. Tambah pula yang dalam UiTM, tak tahulah yang duduk dalam kelas ni anak orang kaya. You are not supposed to be here. ITM untuk orang miskin. Melayu Bumi Putra yang miskin. Dia tak tulis pun Melayu, dia kata Bumi Putra saya boleh masuk apa? Yalah, you janganlah ambil chance orang lain yang miskin yang tak boleh masuk dalam universiti Melayu. You should be studying with Inti College ke whatever private university because you have the money. Kenapa you nak menempel kat sini? Tak, ni saya punya hak. You siapa nak kata saya? ITM tak kena kata apa pun. I mean, come on. Kan? You are not supposed to be here. It is, you know the truth that somebody you have already taken their place. Just because you have a connection, just because you have tak tahulah macam mana kan, but you end up here. So itu discriminatory practices. Cannot run away from the position that there are discriminatory practices that is being going on. Tak apa, saya kenal orang dalam. You know, so if you were to put it as an argument, yeah, though it might be something that is you cannot provide evidence, sufficient evidence, if you were to be able to identify the corruption of the authorities with regards to their position as a person that is holding that power. So for contoh, kita ambil Stephen Poor punya case, what happened to the majlis people, the officers, which is mainly Malay in nature? Macam mana? What happened? One building fall down, two other building is no longer valued. Daripada ratus ribu jatuh, overnight jadi zero. They still have to pay the bank. Why? Because of the collapse. Why it happened? Because how come you approve that project at a place that you know that is very risky? Orang boleh submit semua dokumen untuk nak buat satu projek, you yang at the end will say whether it is safe or not, because you are the guardian of the safety of the society. Oh, tapi tak, when it comes to federal court, oh tak payah, they are protected by the law. Nampak tak? The law, it is what it is. It protects the government officers from doing injustice. It actually promote lah. So lepas daripada ni, orang majlis semua kata, tak apa, Stephen Paul punya case, kita ada landmark case that is saving us. Paling-paling kita buat silap pun, kita kena saman, kita bawa case tu je lah. You have a precedent, my lord. Okay, this case should be removed because federal court has made their decision. Nampak tak? Injustice. Religious intolerance. Cari lah evidence dia to prove it. You want to prove the law that is going to have a impact from Austin. Sebab Austin kata law is what it is. It is from the command. So you have to follow. So if the authority has been given the power, doesn't mean that the authority can do whatever they want and not create intolerance, discrimination, abuses. You have gone through a lot from all the subject that you have learned. Put them in. You have to say that they are yang sini, ingat tak? Tadi you bagi section 302 kan? That is to prove that dia punya teori itu betul. Tetapi injustice, yes or no? So you boleh kata, if you don't agree with me, you say certain laws in with regards to the example that I have given, section 302 is very, very just in nature. There is no wrong with that particular section because we have to punish those people who kill with intention. Because if we don't, then we are promoting people to kill one another. But you have to be realistic. Sebagai seorang law, you kata ada law yang bagus, ada law yang tak bagus. Soalan yang ditanya ialah abuses of the public authority dalam law yang dia orang ada. Because they cannot do anything without the law. So they abuse the law that was given to them, this so-called executive ni, and they are creating religious intolerance. Dekat mana? Bagilah contoh. So you carilah religious intolerance apa yang you boleh nampak that you have learned so far. Dalam federal constitution constitutional law you belajar ada macam kita punya ada tak case that you can give, that you can share? Indira Gandhi. Kenapa baik Indira Gandhi pula yang dia kata, public authority dia siapa? Orang-orang alim agama, Jabatan Agama Islam. Kenapa dia Jabatan Agama Islam buat apa? Ada ke dia bagi hak penjagaan anak just because mamat tu dia masuk Islam, dia tahu dia masuk Islam mesti orang Jabatan Agama sided on his part. Dan terus hak penjagaan dapat kat dia. Mana boleh jadi macam tu? Yang hang kahwin dulu dalam agama lain. You produce an offspring from the moment that you enter into a marriage under different religion. You will at that position. And then somehow or other, you now converted yourself to Muslim, and then suddenly you can, hey, I am a Muslim, and so I have the right to decide the fate of my children. Nasib baik dia bawa pergi ke court. And the court kata, mana boleh jadi macam ni? Nampak tak? Religious intolerance. You do not respect other people's religion. Just because you are a Muslim doesn't mean that you are right. You can do whatever you want. That is wrong. Kalau Nabi ada kat sini pun Nabi tepuk dahi, kata apa engkau orang buat ni? You are creating animosity against God. Because bila you buat benda yang jahat, benda yang tunjuk kata Islam ni kejam, orang tak akan kata Islam tu kejam, orang kata Tuhan Allah tu kejam. Surah An-Na'am 108, you buka tu. Allah dah kata, jangan duk kejam dengan dia orang. Kalau kau kejam dengan dia orang, aku yang dia orang kata salah. Banyak example in religious intolerance that we can give. Okay, so you kena kupas. Macam mana nak kupas? Tadi macam seolah-olah you dah betul lah, Section 302 betul. Bila you apply the law of Austin ataupun the theory of Austin dalam keadaan law public authorities, you akan nampak, betul lah. Betul ada religious intolerance, and I can provide evidence. Indira Gandhi punya case, I can provide evidence. Penggunaan nama Allah, I can produce you evidence. Discriminatory practices, boleh, banyak example that I can give. Okay, human right abuse, banyak. So you can conclude in saying that, yeah, Austin is a good formula to identify a good law. However, it is not perfect. It contains the position that it can be abused by public authorities. And I have already identified them. 5 markah full is given to you if you can do that. Soalan? Boleh nampak? You are showing your maturity in terms of looking at the law. You are not siding to anyone. You are just stating the facts. Kita ni, kalau kita agama apa, bangsa apa, jangan gunakan itu sebagai kita punya objektif untuk nak cari keadilan kepada semua orang. That is wrong. Okay? Boleh tak? Jadi lecture lah ni. Guys, tak ada respon pun?
Boleh, sir.
Boleh, sir.
Boleh lah, lagi 10 minit. Had pula macam mana? Ingat you punya weaknesses is to understand Austin, Hart, Kelson. Kenapa you tak baca? Kalau you baca, you akan nampak Austin punya cerita dia macam ni, Hart macam ni, Kelson macam ni. Bila you dah boleh dapat, you boleh dapat yang ni, okay, yang ni dengan example, then baru you boleh sampai ke A dengan C. Kalau tak, memang tak boleh. Hart pun tak tahu dia punya primary secondary rules. Ada example primary secondary rules? Siapa? Ada lagi 10 minit ni, boleh tekan ni. Naim! Orang lelaki yang kita, perempuan ni dia tak nak aktif ni. Naim, mana? Where are you?
Yes, sir.
Hart.
Hi.
Number 1, number 2, number 3, number 4.
Hi. I mean, they saw the law as a means of social control. What else?
Tak nak, I nak formula dia.
Formula yang primary rule, secondary rule tu ke, sir?
Apa formula dia?
Kejap, yang ni ke yang command plus
Tadi formula kan, maths dia. Buat formula maths. Macam mana?
Command
Lihat equals to primary plus secondary. Betul?
Yes.
Okay, equals to? Is it good law or bad law?
It's a good law.
Alright. So that is the formula. Right? Untuk had kata kalau nak tahu good law, dia kena ada primary and secondary. Now you explain to me what is primary, what is secondary.
Basically, the primary rules is the obligation which impose duties, and then
Which is
substantive law,
and
then secondary rules which creates power and provide procedures and remedies, procedural law.
Procedural law. So substance plus procedure, barulah kita dapat good law. So kalau substantive procedural baru dapat good law, can you give example number 2?
Examples of primary and secondary law.
Yes.
The examples of primary law is the law in I just give section 302 je senang 302
betul,
which is the penal code.
Betul.
And then secondary rules too, I'm not sure if this is right or wrong, but
Hentam
then
je.
okay, hentam. So basically when we wanted to pass the not exactly pass the law, not pass the sentences, we have to undergo the kena ikut criminal procedural code.
Very good. Itu satu. Lagi? Nak bunuh orang bukan senang.
Nak bunuh orang bukan senang.
You pernah pergi masuk penjara tak? You
Setakat
pernah
ni
tengok?
belum lagi, sir.
Kena masuklah pergi melawat. Itulah sayang kita kalau kita ada praktikal boleh bawa masuk kan. Kita boleh tengok orang gantung ke, you know. Nanti you buat part 7 and 8 tu minta nak pergi tengok. Macam saya pernah pergi kot Kudu. Macam mana dia orang gantung orang. Apa tali dia orang pakai. Tali tu berbeza tau, ikut dia punya berat badan. Sebab dia nak make sure benda tu mati. Dia ada prosedur that they have to go through. Untuk nak jatuh hukuman pun ada prosedur. Faham tak? Maksudnya, the primary rules yang kata substantive law to say that section 302, kalau 304 kata if you kill someone then the punishment is death kan. So the procedure to punish you for death sentence tu memang gila-gila punya detail. Ni nak kena masuk court, kena ada charge, kena ada kena ada bukti, kena ada trial. You know, beyond reasonable doubt tak boleh, tak ada doubt tak boleh, semua have to go. All those are the secondary laws that reinforce the primary. Boleh nampak? Guys?
Boleh.
Okay, so you apply dalam ni? Lagi 6 minit. Apply dalam ni? Apply dalam public authorities ni?
When it comes to religious intolerance,
ada yang primary laws tak ada secondary laws, ada yang secondary laws tak ada primary laws. Dia kata hak kata kena ada dua-dua, primary and secondary. Can you prove a law that is able to be abused to the extent that the result is intolerance, discrimination? Yes. Siang kat you. Orang lain. Orang lain mana? Siti Syahanim Sajali. Where are you?
Yes, sir.
Yes. Cuba.
In regards to heart, sir.
Mana mana law yang nampak tak ada primary secondary yang disebabkan itu menyebabkan intolerance, discrimination? Memang susah lah nak kena fikir. I'm not saying that it is something yang senang. Kena fikir. Apa yang undang-undang yang you nampak? Dia tak ada secondary, tapi cuma ada primary je. Ataupun secondary dia bertentangan dengan primary laws.
Could freedom of speech?
Very good. I know you're going there. Okay, good. Freedom of speech then?
Because the
freedom against the?
Against kalau bagi example students, like
Okay.
they can't be very if I try to relate to UiTM, they can't be very political in their speeches. Like they might be threatened to
Good.
like kena keluar dari university or anything.
Tak dapat facility.
Yes.
Kan? So if you are apa orang panggil yang geng pro kerajaan, you might be a victim of that situation lah, because then it's up to you to prove lah kan. So you boleh buat hypothesis in the nature of a hypothetical punya situation, but if you were to have evidence, good evidence, say for example freedom of religion under the federal constitution, that is considered as primary, so it should have the secondary to reinforce the freedom. Tapi kenapa Kelantan kata kena rejam untuk orang yang nak murtad? How can the secondary goes against the primary? That is a question mark, right? Does it lead to intolerance, discriminatory practices and abuse? Jabatan Pendaftaran Negara boleh tukar freedom of orang kata? Freedom of apa lagi freedom yang you boleh dapat yang you tak boleh dapat sebenarnya? Nama je on paper that you are not going to get that. There are other laws that will come in and say, excuse me, it is not. Banyak kan? Hampa duk tunggu masa lagi 2 minit. Tekik je. Can you see that what I'm trying to do is for you to be able to do to investigate. So okay, somebody wants to say something. Anyone? I tak nampak. Yes.
So
apa? Fitri.
Yeah. So maksudnya HAT punya formula for primary and secondary roles is not it can lead to injustice as well.
Yes. That is what we are to investigate. Ada, memang kita kata HAT ni bagus. Primary, secondary memang logik, apa yang dia cakap tu memang logik. Kalau you ada primary, mesti ada secondary. Kan? You have proven that by Section 302, Evidence Act, CPC, apa semua tu kan. Tetapi dalam setengah-setengah keadaan, bila kita pakai HAT punya prinsipal ataupun formula ni, kita tak akan dapat satu keadilan yang menyeluruh. You know, where intolerance, discriminatory practices and human right abuse berlaku. So, kalau pakai HAT nampak macam cantik tapi tak semestinya. So, you boleh bagi 2 jawapan. Yang kata, yes, at certain time, HAT punya rule tu make sense. However, at certain situation, we can say that it's not actually what it is.
So, tapi yang ni belum lagi diluluskan parlimen. Kalau like freedom of association as the primary and
itu lagi ngarut. Dia nak try create a law jumping from one political party to another it will go against the federal constitution. Memang kalau masuk kat federal court gelak je lah. Apalah bodohnya ni parlimen ni.
So kalau undang-undang macam tu wujud, kira secondary yang anti-hopping law tu memang injustice.
Okey, itu kita anggap sebagai prinsipal. Katalah prinsipal tu. Tapi dia bukan prinsipal law. Ada lagi yang lagi tinggi, which is the federal constitution. Because federal constitution is more principle as compared to akta anti-hopping, right? So jadi kalau prosedur bercanggah dengan the secondary bercanggah dengan primary, fail. Formula tu tak lulus. Okay, dia tak menepati formula tu. Okay, dia kata okay lah, let's talk about don't talk about federal constitution. We talk about anti-hopping law. Okay, macam mana prosedur dia? Where is the secondary rules? You buat keluar akta tapi tu tak ada laws yang boleh digunakan untuk anti-hopping. Apa punishment dia? Okay, bila nak punish? Dengan akta mana kita nak punish dia?
Oh.
Macam you buat assignment dalam National Land Code, ada dua-dua. Ada primary, ada secondary. You kata registration of land is paramount. You tak register, bye-bye. Your title of the land is bye-bye. You tak boleh. Sebab kita punya torrent system punya ialah is registration is everything. But kalau kita macam mana kita nak registration tu? Ada prosedur, form apa kita kena pakai, bila kena submit, dekat siapa yang kita kena submit. Those are the secondary rules. Can you see that?
Oh, nampak.
Nampak Okay. I'm not taking up your time anymore. Thank you so much for coming everyone. Assalamualaikum. Take care.
Thank you, sir.
Thank you so much. Hampa bila nak balik dia baru kata thank you. Bye.